জোহার EWS সুদামা কোটায় সুপ্রিম কোর্টের রায় হলো রায় সুরক্ষিত। সুপ্রিম কোর্টের EWS মামলায় নির্ণয়। সরকারি পক্ষের কথা হলো যে 50% জেনারেল ক্যাটাগরি থেকে 10% ফরওয়ার্ড গরিবদের দিয়ে দিলে কি সমস্যা আছে। বিরোধী পক্ষের কথা হলো যে জেনারেল ক্যাটাগরির অনিবার্য আছে, তার মধ্যে থেকে 10% বাদ দিলে SC ST OBCদের লোকসান বা লস আছে। তাহলে EWS এ সমস্ত গরিব সামিল হবে না কেন? প্রফেসর মোহনগোপাল যুক্তি তর্কের মাধ্যমে বললেন, ভারতের ইতিহাসে EWS এমন প্রথম বিধান আছে যার জন্য উচ্চবর্ণ ফরওয়ার্ড কাস্ট থাকা একটি শর্ত আছে।
That passage in Bhim Singh that was read out is actually an obiter. Number 2, that passage has been subsequently overruled in IR Coelho. Yes, it should be taken to have been overruled because, my lords, what has been said now is that in IR Coelho, that even the legislations which are put in the 9th schedule can be tested on the ground for violation of basic structure doctrine. And lastly, taking IR Coelho and Madras Bar Association, my lords have held, particularly also in IR Coelho, march of law. So therefore, precedents and law that has been laid down by this court in Indira Sani is a legal position that tests the basic structure doctrine, and it cannot be said that merely because it was decided in a context of an IO, it cannot be said to be applied to the present amendment. I hope, my lords, I have made myself clear, because I am, and my lords will find this Madras Bar Association paragraph extracted here at page number 18. It's only for the convenience of my lords. I've extracted that particular paragraph. At page number 18, it's the last few sentences of that paragraph, about 10 lines from the bottom, which lays down the structure after recording arguments on both sides. Now, my lords, therefore, my submission will be that Indira Sani 1 and 2, more particularly 2, is required to be treated as a voice of this court, and there is nothing that warrants overruling of the same, or to say that the guidelines, principles laid down in Indira Sani will not apply to the present amendment, merely because that was an OM and here it's an amendment to the constitution. It's the principle. Now, my lords, coming to the next. My lords, it was debated across and also urged by, I believe, by the learned Attorney General, that alternate facts and figures cannot invalidate a constitutional amendment, and this court cannot go into facts and figures for the purpose of invalidating. My simple reply to that is, my lords, it's a very well settled principle that the test of constitutional viris is dependent upon its impact of the state action. It's not based merely on the statement of object. How it impacts finally is the test that my lords will apply to test the constitutional viris. Now, it will not be merely because it sounds that very well we are providing. So, my lords, the facts and figures that have been placed before this court will go to show that the impact of this particular state action actually affects the constitutional, it actually affects basic structure doctrine and has an impact which cannot withstand the scrutiny of this court. Now, my lords, it goes to the very core idea of the equality. That's the principle. Now, my lords, the learned Solicitor General, and I think this is an important response that we need to consider, and it was also argued by my learned friend Mr. Gopal Shankar Narayan, as I heard it just now. It is suggested that not all incursions into the basic features destroy the basic structure of a constitution. What was said was that the alleged breach of basic structure is not a mere violation unless it is shocking, unconscionable, unscrupulous travesty of quintessence of the constitution. My lords, please put it on a test. If this proposition is accepted, then you can go ahead, hit the basic structure of the constitution chip by chip. Go at it chip by chip. It's not shocking, it is small. You'll have a next one. Now, where this principle comes from If my lords may just give me the benefit at page number 21 of my submissions. And my lords, I just have very short ones. I'll finish with this very quickly so that my friends have an opportunity and I don't eat into their time. My lords, the principle comes from what is called page number 21, paragraph 19.1, about third line. The principle that comes here is from the ship of Keyser's paradox in philosophy, offers a relevant parallel. If over a period of time, every single part of a ship is replaced by a new part, at what stage does a ship become a new ship? And therefore, if we accept this proposition, that it's not shocking, it does not affect, it is something very small, and we can go at it slowly chipping away. We will one day do not know whether the ship is new or it was what was expected by this course on the principle of a basic structure doctrine. So, my lords, I would respectfully submit that a proposition of that has to be taken with utmost caution and utmost restraint, if I may say so. Now, my lords, I come to the next submission, which is made by by a colleague, learned Solicitor General. The primary argument that is said was that the Constitution does not allow for migration of SC/STs, who are the most backward, to vertical reservations created for SCBCs, which are relatively less backward. Now, Constitution can create another zone of affirmative action. This is the argument for EWS category, which exists outside the fold of pre-existing reservation. My lords, I would respectfully submit that first of all, we are not here in this matter and we have not tested that principle of migration of SC/STs into the OBCs. There is no argument that is advanced. It is an area that should be left at the time when there is an issue that is raised. Having said that, in any case, in R.K. Sabharwal and down the line, my lords have recognized that while there is reservation for SC/STs and OBCs, that does not prevent them, whether it is under 16.4 and 16.4a, to move into the general categories if they are so meritorious. Now, if migration there from the reserved category to the general category is permissible, now this is taking back to EWS, which excludes other than classes mentioned in clause 4 and 5 of 15 and 16, apply the same test then there. Please consider it that we are then, people are only, there is a limited, I have already argued it, I am not reiterating. Proportionate reservation is never envisaged under 15 and 16. Only area where proportionate reservation is envisaged, and I think there my learned friend should have pointed out, Mr. Gopal Shankar Narayan, is under 343D and 343D. That is where reservation for scheduled caste, scheduled tribe is proportionate to their population in a constituency, but not under 15. Now, if they are not proportionate, their representation within the reservation class is small and limited. There are many which are left out. There are many which are left out, which may also be eligible under EWS. So therefore, to exclude them by saying that no, there is reservation for them, will be actually failing the test and failing even the test of R.K. Sabharwal, which recognizes that you can be considered under the general category. Now, my lords, very quickly, there is an argument that is suggested that exclusion of EWS from EWS is not that of caste, but that of classes who are already receiving the benefit of a special provision. Now, my lords, in this, my reply is, this argument is completely fallacious in my respectful submission. The reservations have been made only for adequate representation and have not been given in proportion to their respective population for each group. Therefore, even within those classes receiving the benefit of reservation, the individuals within the same group, despite being recognized as backward, are unable to receive the benefit. There is therefore no justification advanced to discriminate against them, particularly on an economic criteria, which can only be a lateral consideration. Now, my lords, is just I'm just moving on. Then, my lords, then there is an argument on a breach of 50% limit. My lords, I have in paragraph 24 dealt with it in detail. I am not going to take the time of my learned friend, But here I have only one submission. Learned solicitor, one minute. Learned solicitor handed over this particular thing saying that there has been an increase of seats, etc. Please, my lords, we cannot forget the fact, whatever be the number of seats, the principle of reservation as envisaged under 15 will apply, and it is not the case made out by the government. So therefore, it will be 50, 40, whatever percentage will apply to these seats. So there cannot be that we have increased the seats, so therefore we have another 10%. Lastly, my lords, there is no mention under 16 whether there is a job opportunity. This is only in the education sector. This is my last point, and this is on the doctrine of severability. I accept the argument advanced by my learned friend on severability. I believe that if my lords were to uphold this, the deletion of the last portion, other than classes mentioned in clause 4 and 5, will serve the purpose. And this principle, my lords, it may not be reading down principle here. I have dealt with in my submission. It might be on a severability. And here, my lords, I place that judgment of Hiralal Hansora versus Kusum Hansora in the domestic violence case, where my lords applied the same test of severability and deleted the...
Thank you.
My lords, can I have just one thing? Just one line, okay, one line. My lords mentioned about the guardrails for so far as the economic weaker section is concerned. Now, my lords, when the principle is a single criteria of economic backwardness or an economically weaker section, then that cannot be applied differently to different segments of the population. The guardrail is only one, economically weaker. There is no other guardrail. So, my lords, I leave it at that. My lords, I am grateful. We are sorry if we are overshooting our.
I am making 4 points very quickly. I'll try to finish it, my lord, in 5 minutes. My lord, we had seen, my lord, that the debates, parliamentary debates which are there, which I read out, and even the Constituent Assembly debates which are there, and the provisions, First Amendment, etc., clearly pointed out that as far as the economic criteria was concerned, was something which was excluded. It was not taken into consideration. Actually, I did not mention, but Granul Austin points out, my lord, that at one point of time when this was being drafted, then the economic criteria came in because the Chief Minister of Madras said that it should be included. But when it ultimately bill went, then the economic criteria was something which was not there. The sum and substance is, my lord, that when you look at the social, educational, and naturally, my lord, the economic criteria comes in. What Justice Jeevan Reddy points out is that the social backwardness, my lord, leads to educational backwardness and then economic backwardness. But assuming we reverse the position, my lord, then in the reversal also, it is not something that economic criteria alone can be there. Now, that is something very important. The economic criteria, if you reverse the situation, my lord, as pointed out by Justice Desai, Justice Chennapareddy, even in that situation, it is necessary that the component of education backwardness and social backwardness, they come in, because they form ultimately, my lord, as we saw the entire debates and discussions in several judgments, really forms, my lord, the equality clause. And that equality clause, my lord, is the basic structure, ultimately drawing at that. And therefore, if you have only the economic criteria, in my humble submission, cannot be the basis of the basis of structure, my lord, which sustains the constitution. So that's not my point number one. The second point is that because the idea ultimately is that you have the equal and unequals, and then you are trying to really see that the unequals strive to not achieve that kind of equality. The second point is, my lord, as far as the circles are concerned, I have little doubt about the circles, because according to me, we cannot put them in, my lord, SC/ST in a smaller circle and then backward classes in the other one and then bring another circle. In my submission, my lord, there is equality, the overall equality, which is one circle. In that circle, we have persons whom we called initially the backward, because SC/ST and backward classes, subsequently it was included because the term which was used was only backward. So within that circle, the idea is that ultimately that they strive and achieve the equality. So therefore, my lord, these are two circles which are there, and the outer circle which remains, my lord, outside this 50% as we call it, is a circle which is general in nature. We cannot put it, my lord, that this is a circle and versus the other circle. This is for generally for everybody. You cannot bring in any kind of reservation within that particular circle. If possible, what can be done is, because that is something, not the small circle is governed by 15.4 and 16.4, if you put it not that way. The other circle is 15.1 and 16.1, which is the equality clause read with 14. So in that circle, if you want to do something, what is permissible is the horizontal one. You cannot have vertical reservation in that. Because the moment you do it, then what Ambedkar pointed out, that you are virtually negating the entire principle, which even of reservation, because 70-30 example which was given, that you keep on doing it and then the entire principle of reservation, etc. is nullified. Now, my lord, my third point, I think I mentioned this about that you can't have what London Attorney General argued, that 50% reserved and which is one category and 50% is other, and therefore we are not touching that. I don't think we can put it, my lord, as versus something that no, this has been done, and because we have given you everything, therefore we are giving it to other persons. It cannot be. And in one sense, my lord, if you do that, then it becomes caste-based reservation or communal reservation, which has been argued by Professor Verma. Now, my lord, my fourth point is, I am rushing very quickly, my lord. The fourth point is about the creamy layer. Now, my lord, the question is that if we bring in this principle about the SC, ST, OBC, that on the basis of economic criteria, because 8 lakhs limit is there, 8 lakhs limit is here, and therefore you cannot distinguish or differentiate between the persons who are economically weaker. But the difficulty will be if you, as far as the SC, ST are concerned, because this creamy layer limitation doesn't apply to them, then that part has to be resolved. And that is not permissible if you bring lot persons here. I hope lordships have followed. That is to say that if you give the benefit, the criteria, economic criteria which is there, the cutoff 8 lakhs, which is also creamy layer and here, their SC, ST are not governed by that. You bring them here, then that particular limit will come which cannot apply to SC and ST in that sense. Other argument is about Article 21A. That argument has been advanced because the definition includes, my lord, the SC, ST and backward classes. It's not merely the EWS criteria. My lord, lordships must just note that page in Granville Austin, that is volume 4, 1530. I am not giving the pages, my lord, of Indira Sani and other cases. But I am trying to, my lord, say that shift the position from economic criteria to this one of social backwardness to economic criteria. Ultimately, the essential component of social backwardness, education backwardness should come. Then only, my lord, equality criteria and the basic structure we say will be something. My lord, what we have done is just pass on. Some questions which are put and answers which are in 3 pages. If your lordships will not wish.
Thank you.
Yeah.
Now don't read that, we'll read it.
I am very grateful, my lord. Quickly I summarized, but then I hope I was able.
Yes, Mr. Chaw.
May I please, my lord?
Who follows after Dr. Chauhan?
Professor Mohan Gopal. My lord, I have only 2 issues which I want to agitate, my lord. First is, my lord, have taken a view that this is a constitutional principle. So the interpretation or the basis has been removed. So I have to see the constitutional philosophy of Article 141, read with Article 145(5) of the Constitution, my lord. As per the scheme of the Constitution, my lord, the precedent value of a judgment of this honorable court is decided, my lord. Whether it is a constitutional provision or a office memorandum or a order, my lord, when my lord have to test it from a different point of view, if my lord finally decides that this doesn't violate basic feature, my lord. So my lord have to respect the larger bench of Indira Sani, my lord, because that principle has to be respected and there should be discipline. Because my lord, in Nagaraj, when Nagaraj was argued, I have raised this issue, but Nagaraj was not referred to larger bench. Even today, after 16 years of Nagaraj judgment, in 2006, Nagaraj was decided. In almost all states, there is no reservation in promotion. And only central government, some services reservation promotion is being followed. So this should not happen, my lord, because the discipline, the judicial discipline of precedent and the bench composition or the hierarchy of the bench, my lord, that should be followed. This is my one argument. The second is, my lord, the learned Attorney General has said that the scheduled caste, scheduled tribe are loaded with so many benefits, my lord. So I could find a article, my lord, regarding American in context, my lord. Professor Owen Fish, he has written an article, Accumulation of Disadvantages. So this article basically I want to read for a purpose, my lord, because he has defined that those people who have been historically disadvantaged group, they can only be classified, and their subjugation should be continued, my lord. And otherwise, it has many aspects, my lord, which will take time. So I want to just say that, my lord, have to see the historical context, my lord, the deprivation, social exclusion, the untouchability. Professor Ravi Verma has tried to say that scheduled caste should be bifurcated. When a president of India from the scheduled caste, he goes to a temple and he is not allowed entry. When they go to another temple, his wife was just pushed, and both the cases, criminal cases are going on for this. So what is the difference between a scheduled caste who is a laborer and who is a president? So my lord have to consider all those aspects in mind, because this is a class of a different nature, and we don't want that this reservation should continue. But there should be some reason by which it could be changed. The reason by which the reservation system could be changed is to emphasize on caste, because the deprivation, the discrimination is because of caste, not because of his economic condition. If the economic condition would have been the basis,
थोड़ी देर बाद आने दीजिए. Yes, go ahead.
if the economic condition would have been the basis, then this type of discrimination would not have been there. And my lord, other aspects I have already argued that social democracy and others. Now I think Dr. Mohan Gopal.
Thank you. Who's there now next to?
Professor Mohan Gopal is
Yes.
sitting a little awkward because we have all reached into his time also.
So we started with Dr. Mohan Gopal.
Submission, my lord.
Sir, I do not
One
want
short
to
submission to
inconvenience-
make-
No, that's all right. We'll go ahead for, how much time would you require?
Sir, Gopal, other than Mohan, namely Gopal Shankar Narayan, has taken up half an hour of our time unexpectedly. We did not know that. So I have no time left, sir. I want to make, I had a couple of substantive points to make, and there's no time for that. But your time is far more precious than my.
No. Please, we will try and accommodate. Yes, to the extent possible.
I have only one singular submission to make, my lord, at the end.
Mr. Kalishwaran, please now.
Yes.
Yes, sir. Whatever you say, sir. I'm at your disposal.
I,
Disposal.
Rather, Dr. Mohan Gopal,
Yes, sir.
give you half an hour after lunch.
Yes, sir.
After lunch, and that's the last word in the matter.
Yes.
Mr. Kalishwaran, whatever you wish to say, next 5 minutes, sir.
yes, I can. Can I do it now, my lord?
Yes, right now.
Yes. My submission is only this, my lord. I just wanted to make a rejoinder with
Yes, sir.
respect to this already provided for argument. advanced by the learned Solicitor General and by the learned Attorney General. The already provided for argument, that is to say, that you have already given the 50% is not a valid argument for two reasons. Number one, as this is what was pointing out, the fundamental rights are always individualistic and it is not a class right. Therefore, to say that OBC or SC or ST is given the benefit of reservation as a class is not an answer when the fundamental right violation is alleged. Again, this was dealt with, this fundamentality or the individuality of the fundamental right was specifically dealt with in paragraph 108 of Puttaswamy, 2017 10 SCC page 1 at paragraph 108. But one single sentence answers it all. This is the sentence I quote. The individual is the focal point of the Constitution because it is in the realization of individual rights that the collective well-being of the community is determined. Unquote. If my submission, therefore, is that if the benefit is given to us as a class, that is not an answer when we allege that in the context of exclusion, our individual fundamental rights are violated. That is the answer to that. Therefore, I would therefore also say that if in Puttaswamy it was said that if individual is the focal point of Constitution, I would respectfully try to place with your lordship that what is focal point is also part of basic feature of the Constitution. Therefore, this violation of individual fundamental rights can also be termed as an infringement or as a violence to the basic feature of the Constitution. This is my submission on that. Secondly, very briefly, rather than coining it as an equality code, I would respectfully point out that the key test would be to see whether there is discrimination. That is to say, anti-discrimination will be at the core of the basic feature rather than the broader or rather the wider or rather the abstract category of equality code. The question is in the context of exclusion whether there is discrimination or not. But that will alone will answer the question. And lastly, in conclusion, I want to thank your lordship for streamlining it in such a fantastic way. And I am reminded of modulating the whole deliberation in such a fantastic, disciplined way. I am reminded of what the Times said about one of the novels by Gabriel Garcia Marquez. The sentence read like this, quote, "There is not one stale sentence, redundant word, or unfinished thought." Obliged.